You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't. Hi, Chad Franzen here, one of the hosts of Share Your Voice, where we talk with top-notch law firms and lawyers about what it takes to run a successful law practice. This episode is brought to you by Gladiator Law Marketing, delivering tailor-made services to help you accomplish your objectives and maximize your growth potential. To have a successful marketing campaign and make sure you're getting the best ROI, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. David Lowe is a registered patent attorney with a technical background in computer science and software engineering. He is a first-chair intellectual property litigator and founder of Seattle IP boutique law firm Lowe Graham Jones. David has experience in all aspects of intellectual property law, both in the United States and foreign countries, including patent, trademark, and copyright procurement, with an emphasis on intellectual property litigation and related client counseling. David is admitted to practice at all levels of federal court and in various states across the country, and helps clients of all sizes throughout the U.S. and many international jurisdictions. David, thanks so much for joining me today. How are you?
You bet. Happy to speak with you.
Hey, so tell me a little bit more about Lowe Graham Jones and what the firm does.
Sure. We were founded in 1999, July 1st, in the middle of the dot-com boom, when there was a crazy need for intellectual property attorneys. I came out of law school in 94 from the University of Washington and started to practice with a local Northwest firm called Christensen O'Connor. Spent about 5 years there, was a senior associate, learned everything that you kind of needed to do for the practice. And there was just people banging down the door. They wanted patents, they wanted copyrights, trademarks, because again, that was the dot-com bubble, if you recall, back in that time, and there was just not enough IP representation. So myself and a couple of other senior associates founded the firm at the time, Black, Lowe, and Graham. Subsequently, one of the partners left, and we became Lowe Graham Jones in 2011. But we are a boutique firm. We specialize only in intellectual property, both procurement of trademarks, patents, copyrights, as well as enforcement of those rights once they're procured, as well as related issues, trade secrets and the like.
How and when did you know you wanted to become an attorney?
It's a good question. I've been asked that by my kids many times. Back in high school, I grew up in a rural Eastern Washington on an asparagus farm of all places, but I had this passion for two things. I loved technology and science. Again, this was the early 80s, and I loved speaking. And so I joined the school's debate team, and went to state and regionals, did a lot there. And then also I participated every year in what's called the science fair. I don't know if you remember that from your own high school.
Oh, yeah.
Where all the geeky kids get together and they work on experiments and they go and they compete. And I did that and went to International Science Fair for 4 years. So I had this desire to do both. I love technology. I thought about going into science. I love speaking. And so I went off to a school at Brigham Young University and started out in computer science and engineering. And it wasn't until I got near the end of that program that I decided that, wait a minute, the best way to blend those two was to go to law school. So off I went. And it was only about the second year of law school that I kind of stumbled upon intellectual property. And there you get to deal with people on the cutting edge of technology, working with them. You have to kind of keep up to speed on the technology while still knowing how to translate that into the legal realm and to secure rights and enforce those rights.
So you didn't necessarily know that this is what the kind of the legal niche that you were going to follow when you entered law school, or did you know that right away based on your background?
Well, not really. It's interesting. In the early 80s, there was about 5 million general practice attorneys and, maybe 100,000 intellectual property attorneys. It just wasn't a big demand. It wasn't a big specialty. Back then, there were boutique firms, and most of the general firms didn't even have IP departments, intellectual property departments. And so it wasn't until I kind of stumbled into this. In fact, one of my professors at University of Washington was Don Chisholm, who happened to have literally wrote the book on patent law. And so he kind of got me into that. And University of Washington, of all places, because of his influence and others, was kind of really keen on a pathway to take these attorneys that have technical backgrounds and move into intellectual property. for patent law, many people don't realize this, but for general practice law, you can have any kind of background, political science, English, whatever you want. It doesn't have to be science, and you can sit for the bar and you can become authorized to practice. But there's a separate bar you have to take offered by the U.S. Patent and Trademark Office in Washington, D.C., to be able to represent people to secure patents because of the technical nature. And so it's a very small percentage of people that go to law school that have the technical background necessary to sit for the patent bar. And so that's why there's such a few number of those. And it's very hard to pass. The pass rate is like 35% compared to 75% for general practice bars. So you really have to take two bars, which makes it a very small kind of a group, both locally and nationwide.
I don't know that much about I know I'm not very good at computer science. Does does it require a whole different way of thinking when it comes to computer science as opposed to law, or are they similar? I would think that they're pretty different.
Well, you raise a good question, and it's a point that I've made repeatedly. So most of the patent and trademark attorneys, intellectual property attorneys, they do either one type of law, transactional law, or a different type of law, litigation or enforcement, right? So for example, in patents, you have to be very detail oriented. That's why a lot of scientists and people with science backgrounds become that. You've got to be very meticulous about how you describe inventions, how you claim inventions, how you argue back and forth with the patent and trademark office to secure patents. That kind of transactional work lends itself to people like engineers who are science related, computer scientists and the like. On the other hand, you have people that are better, like to speak, right? Like to argue, like to debate, things like that, like to present in front of a judge or a jury. That's usually a very different type of an outgoing personality than you get with engineers. So what you have in most practices in intellectual property is a division. You have your group within these firms, boutique firms or large firms that do intellectual property, a group that does transactional work, that works on prosecuting patents, securing trademarks, securing copyrights, but they really don't get involved in disputes or go to court. Then you have a different group that doesn't really do the prosecution. They just go to court, right? They work with clients, they go and litigate, they make their presentations, they argue their cases. Actually, there's myself and a few at our firm are really kind of a maverick in that we combine those two. Very few people can do both the prosecution of intellectual property and litigate. And as you saw from my resume and what we do, myself and a couple of my partners are unique in that we both get it. We understand how to prosecute patents and trademarks on the one hand, but we also can present to judges and juries on the other hand in a convincing and compelling way. And I think that leads to the very best type of attorneys because on the one hand, given that you prosecute patents and trademarks, you understand what it takes to get those. You understand the process of negotiating with the Patent and Trademark Office. And that makes you better at litigating because then you understand the backdrop and the context for these patents that you're enforcing. On the other hand, I think the fact that you litigate and you enforce, you stand in front of a judge and jury and you have to explain these things to a lay perspective makes you that much better about knowing what you need to do in terms of prosecuting these patents. So very few, if you look at out of the the attorneys that are out there in intellectual property law, very few do both patent and prosecution and litigation.
Yeah, absolutely. I would imagine. I was going to say you guys are like kind of unicorns almost. I've met the people who help fix my computer where I work, and while they're very good at their jobs, very nice people, I wouldn't want them necessarily communicating on my behalf. So you guys are very unique in that respect. What is it that you like most about what you do?
It goes back to my years growing up in high school. I love both the technology. I mean, literally by definition, to obtain a patent, it has to be something that's new, novel, not obvious, something that's not been done before. So when you work with inventors, whether they're sole inventors in a startup company, whether they're someone that works at Boeing or Amazon or Microsoft, no matter how big or small, those inventors are on the cutting edge of their fields. And so to be able to work with them, harkens me back to the days about my experimentation in my science projects. I love that aspect of it. On the other hand, I love the ability to enforce these patents, right? To counsel with clients. Look, I I always urge people to avoid litigation. I do everything I can ahead of time. An ounce of prevention is worth, how many pounds of enforcement later on. But I always urge people to take the steps necessary to protect their rights, to keep them out of litigation. But when it eventually happens, and it's almost inevitable if you're in business these days, then I enjoy working with people, interacting with the clients, again, whether they're small startups or whether they're large companies, and be able to counsel them on how best to enforce their rights, defend their position, whatever it takes.
You told us a little bit earlier about the about how Lowe Graham Jones kind of came about. What were the early days at the firm like? I know you'd already been working for 5 years after law school. What were the early days of kind of having your own place like?
Yeah, well, I'll tell you. So there were three of us senior associates that left the same firm and started our own firm. And for the first 6 months, we rolled up our sleeves and we said, okay, look, we did it the right way. We left. We did not tell any of the clients that we had worked for at the other firm that we were leaving until we'd put in our notice, given our 2 weeks, and we'd left. And then we reached back out to them and we said, look, we're starting a new firm. We're happy to work with you if you want, or you're welcome to get handed off to other attorneys at the firm. And we got out word of mouth, and we managed to really all the clients we had worked with before elected to come with us. We were young, we were aggressive, we're all similarly situated, we're all 30 something with kids and a really a focus on style of living, but we were willing to work hard. And we started out and said the first 6 months we're going to just literally operate out of one of my partner's basements. We were virtual at that time. Long before it became vogue to be virtual, we were virtual, right? We got our letterhead, we got our business cards, we reached out, and clients came to us. And we were able to make that transition and continue doing great work for them. We were lean and mean, our rates were very competitive. We were very efficient what we did. We weren't bloated like so many law firms get. And we're able to do a great job. And and the way we do our compensation structure, we started out with three of us and quickly grew to a dozen attorneys because we attracted laterals, other attorneys that had a similar kind of a mindset and a style. Again, that was in an age where, the 80s, 90s, firms have become so large and bloated. And, the overhead rate was 60% when it should be 30%. And you had a situation where the clients started to realize, wait a minute, why are we paying for the A plus space and the great view when we can get the same or superior work done for a lot less? So we're able to find that niche, combined with the fact that there were just so many companies in that .com bubble looking for attorneys, looking to have work done, looking to get patents and trademarks filed quickly. And it was taking just so long at these larger firms that were slower to act. And so that allowed us to get off the ground. Again, within the first year, we grew from 3 to a dozen attorneys. And, we haven't looked back since.
Yeah, it sounds like you guys had some amazing growth and it happened right away. Was there anything maybe from a business perspective or something that you guys kind of realized that none of us really knew this?
Well, I mean, it's nothing revolutionary. It's things that go back, the hundreds of years, thousands of years. I mean, I think there's two keys. And, you're here, I know, focusing on marketing, and I think there's a lot that be done. This kind of a presentation, having a good website these days, having some advertisements may or may not be good. Over the years, we've done advertisements in local bar journals and things like that. But to be honest with you, the two fundamental things that I think that make a successful law practice, at least to have been for us, come down to things that are the same kind of qualities that people have been looking for centuries. And that is, number one, provide good service. For us, provide quality legal service in a cost-efficient and timely manner, because this leads to continued representation of those clients and repeat business. Be responsive. I mean, you sacrifice a little bit on the home front, but I get calls and emails at all kinds of day or night and on the weekend, and I get back to people, right? Because in the legal field, at least, when people have a problem, they churn and churn and they want an answer, right? And that's what we're here to guide that. So be responsive. And then the other thing is, it's important to always be honest with your clients. And even if the outcomes aren't good, our job is to give you the tools to help you make a business decision, you as the client, right? Good or bad, here's the risks, here's the rewards. Now you go make a business decision. So one thing is provide quality legal service. And if you do that, you're going to get referrals. I can't tell you how much of my business comes from one client referring another. Hey, here's a great attorney. He's very responsive. He's very efficient. Go to him. The second thing I would say is lasting relationships, right? Not just with your clients, but especially with other attorneys. So because we're a boutique firm, we specialize in intellectual property, patents, trademarks, copyrights, trade secrets. We don't do slip and fall cases. We don't do employment issues. We don't do corporate structure, things like that. So we have relationships where we've made over the years where, hey, if you've got an employment question, I'm going to send you to my friend down the way. The practice is there. On the other hand, if they have any kind of intellectual property question, who do they come to? They come to me. And you've got to be willing, I think, to spend a few minutes. They talk about pro bono in the law profession, donating time and things like that. I don't track it, but I can't tell you the number of hours, over the weeks, months, years I've spent just answering calls, potential clients or other attorneys. And a lot of times that doesn't lead to a direct billable event or compensation at that time. It's okay. I'm willing to spend a few minutes and answer a question, and maybe it'll go a whole different direction and they won't need my assistance. Because every time you do that, you establish and reestablish that relationship. And that makes them comfortable, these other attorneys, to come back and ask you later on, hey, I feel comfortable with you representing my client in this intellectual property question, knowing that I'm not going to lose business to you like what happens at a large firm. Large firm, they have IP departments. Somebody refers into there, and then they have a tendency to try to suck all their other business away. We don't do that. So it's about keep preserving those relationships. The last thing I would say is over the last 15 or 20 years, we've become a global firm. And so we have a fair amount of our work that comes from all over the world, Europe, China, Southeast Asia. And it's because we establish these relationships with equivalent intellectual property attorneys in other places, right? Now, over there, interestingly enough, unlike in the US, I can be a patent attorney that also goes to court. You may know that in England, they have barristers and solicitors, that there's a big demarcation between transactional work and others. And so I'm able to appeal to both, and that's the way it is in many jurisdictions. I'm able to appeal to both those that want transactional help as well as enforcement help. And, for instance, every year I go to something called INTA, International Trademark Association, where there's 7,000 or 8,000 trademark attorneys from all over the world to get together. I just got back in May from Singapore, where we had a conference there. So every year they have a different location. You meet with those, you establish those relationships. They send me work, I send them work, and that represents, 20 or 30% of our overall business. So I think quality legal service, and I think those lasting relationships, in addition to being visible, marketing, website, things like that in the community, but those are the keys.
Sure. Well, it sounds like you've had some amazing growth. I mean, to go from a basement to being global is amazing. Is there maybe like some specific moments or milestones that you're particularly proud of during the lifespan of your firm?
Yeah, good question. I mean, they often say that a business has to last, 2 years to be able to survive. So, July of 2001 was a key moment, right? Where we were 2 years and we looked at each other. Now, by that time, it was interesting. We started off in the basement the first 6 months. We kind of stumbled into, so you remember there was a dot bubble in 99, 2000. Then about 2001, boom, the bubble burst, 2002, right? Mm-hmm. And then you went from having all this work and this clients to having a lot of empty space. All these startups in Seattle disappeared. And so we happened to stumble onto Martin Seelig that owned several buildings in Seattle that had a third floor of an 1880 built building above the Metropolitan Grill. And so we kind of gravitated from the basement. We signed our first lease. And we're actually downtown and official, right? You could look down the road and you could see the Mariners Stadium and look up the street and see the Space Needle and look out over the water. It was a great location, but it was a B space. But we still kept all of our clients. We started bringing in more support staff. I told you we grew to about a dozen people, and then we just took off. So that was kind of a key moment where you hit that 2-year market and you move. Another key moment was in 2011. At that time, we had one of our original partners that left, decided to do a different area of practice and took several associates and went in-house. That was a bit of a setback, right? You go from probably 15 or 18 attorneys down to 10 or 11 at that point, right? And so we kind of had to regroup, keep the core together, change our name to Lowe Graham Jones. and then take off. And about that time, within a few years, we gained several other laterals, and off we went. And we experienced a pretty significant growth between about 2011 and probably 2018, 19, and then COVID hit. So I guess a third milestone, and it's probably not unique to many other businesses, was tough because COVID, we saw not as much a diminishment in work because we had established cases and clients and people needed work, but it's just a whole new style of how you operate, as you know, right? We had many more people that were locked down, especially in Seattle area where they locked down a ton of people. You weren't able to go into the office. So we really kind of this transition to virtual. We reduced our footprint. We changed offices. And, a lot of us who left then didn't ever go back or didn't go back on a regular basis. But we're still strong. We still have, what do we have, 12 or 13 attorneys now and staff, but they're just spread out more, right? A lot of them work from home at different sides, but we still provide work. We still got a great core. We've been able to keep throughout the 20 plus years of our existence coming up. We just passed, 24 years now. We've still been able to keep, our core values, which are lean and mean, low overhead. We aren't the cheapest firm, but we aren't the most expensive firm. And we offer that sweet spot to clients, not only locally, but up and down the West Coast and throughout the country right now. And we love what we do.
You mentioned lean and mean. You grew pretty fast. You started in 6 months in the basement. You were already hiring new people. Was it a big leap of faith or kind of a gulp to bring in somebody new and know that they were going to be on the payroll and doing things that maybe you were used to doing?
Well, it was a leap of faith. I mean, I remember with my partners when we decided to leave in 1999 saying, look, we have a steady salary. We have, we all got families. We have mortgages. We have obligations. Do you really want to do this? And we said, yep, let's do it, because we were confident in our own abilities, right? And the circumstances, the environment was right. Well, the same kind of thing when we decided to grow, we said, look, the way that we structured our firm, it's not what you call an eat what you kill type of a firm where you just get based on your billings, but it's also not the kind of firm which we never did like, which is bloated. In most firms, they give you a set salary. They have the compensation committee that goes in at the end of the year, and they evaluate that and they say, well, we think you're worth more, or you're worth less, or things like that. We didn't like any of that. So we created a system in 99 where it was objective, right? It was based on what you originate, what you bill, and how you help manage the firm. But it's all in a business model that is highly transparent. Everyone can see what they're doing. If you want to work more hours, you're going to make more money. If you want to take more time off, you don't. Unlike most films, we didn't have billable requirements, right? You could really gauge what you wanted, but we were all out there and aggressive and wanting to work and develop our practices. So we knew, because of the people we brought on, that it would be successful. And instead of having this, mysterious compensation committee, everybody knows we made them partners early on in the process, a piece of the action, so to speak, and it provided this incentive. I mean, instead of most law firms, which put you on a membership track to 7 or 8 years, you could be a member invested after 2 or 3 years, right? So there was highly incentivized to really take ownership of this firm and grow it. So for those reasons, it was a high risk, but a high reward. And we really brought in people that were like us, more entrepreneurial in nature than those people that just wanted to be plotters and get a stack of papers and work through it and get their salary and go home.
Well, it sounds like you guys are a very unique and forward-thinking firm. I have one more question for you, but first, how can people find out more about Lowe Graham Jones?
Well, there's a couple of ways. Our website, Lowe Graham Jones, LOWEM GrahamJones.com. And you can look us up. I'm listed there. You can give me a call. Like I say, I touted my responsiveness. I'll be responsive. 206-335-3303. Give me a call. You can shoot me an email, Lowe, L-O-W-E, and then the name of our firm, LoweGrahamJones.com. So there's a number of different ways. Our website has some general information about our practice areas. If you have any kind of intellectual property needs, if you have an idea or an invention, you're not quite sure whether there's anything, give us a call. We're happy to spend a few minutes and help guide you. Maybe it'll turn out to something, maybe not. If you've got a great brand, a trademark, if you've written something, a book, a website, if you've got an issue with, I've got this secret, how do I interact with my employer? Because this is really separate from them. Any of those kind of questions, we're happy to help guide you, and just give us a call or shoot us an email and we'll follow up.
Hey, last question for you. You mentioned that you guys were kind of remote before remote became in vogue. How did remote work look when you guys first started doing it compared to, how it is now?
Well, it wasn't nearly as acceptable, right? I mean, when I started practice in the early '90s, it was still suit and tie every day, right, and 5 days a week. And then it wasn't really until what the late '90s, early 2000s when people started going more to business casual. And so at the time, people were still, I want to be in person. I want to be able to walk into a law firm, see the brick and mortar and that kind of a thing. So it was tough at that time, right? Because we didn't have a presence. We had to rent space if we met with clients back at that time. But again, because we were so responsive and we were willing to get back to people and they liked the results, we managed to kind of smooth that over. We didn't really have much of a hiccup in the transition. Now, that didn't change, of course, for another decade or plus, right? And COVID was really the final nail in the coffin. And people says, we don't need this brick and mortar anymore. But it was interesting, even 20 years ago when we first started doing this, that because we were willing to travel to clients, go to the businesses, meet at other locations, it seemed to work out all right.
Sounds good. Hey, David, it's been great to talk to you. Really appreciate your time today. Thank you so much.
You bet. Happy to speak with you.
So long, everybody. Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.